Getting a divorce in Texas is actually simpler than you might think. One spouse must reside in Texas for 6 months before a divorce can be filed, and be a resident of the county for 90 days in which the divorce is filed. Also, there is a 60-day waiting period after filing before a divorce will be granted. Once that is complete, a legal grounds for divorce must be established. In Texas, both general and no-fault divorce are acceptable grounds for divorce. The no-fault reasons for divorce in Texas are: the marriage has become insupportable because of discord or conflict of personalities that have destroyed the marital relationship and prevents any reasonable expectation of reconciliation, or living separate and apart without cohabitation for 3 years. The reasons for a general divorce are adultery, abandonment, confinement for incurable insanity for 3 years, conviction of a felony and imprisonment for over 1 year, and cruel and inhuman treatment. Texas does require a parenting plan for child custody. Joint or sole custody is according to the best interests of the child. The sex of the parents is not a factor for consideration. The other factors considered in the terms and conditions for visitation of a child by the visiting parent are the age, circumstances, needs, and best interests of the child, the circumstances of the parents, evidence of any spousal or child abuse, and any other relevant factor. The factors specified for consideration when making these decisions are whether the physical, psychological, or emotional needs and development of the child will benefit, the ability of the parents to give first priority to the welfare of the child and reach shared decisions in the child's best interests, whether each parent can encourage and accept a positive relationship between the child and the other parent, whether both parents participated in child rearing before the filing of the suit, the geographical proximity of the homes of the parents, if the child is 12 years or older, the preference of the child, and any other relevant factor. The court may not award joint custody if there is credible evidence of spousal or child abuse or neglect. Parents may file a written agreement with the court regarding joint custody. The court will award joint custody based on the agreement if it establishes the county of residence of the child, states the rights and duties of each parent regarding the child's present and future care, support, and education, includes provisions to minimize disruption of the child's schooling, daily routine, and association with friends, was entered into voluntarily and knowingly, and is in the best interests of the child. There are standard terms for court-ordered child custody set out in the statute, which are the minimum allowable time that the parent who is not granted the primary physical residence of the child is to have with the child. Either or both parents may make periodic, lump sum, or both types of child support payments. There are official guidelines set out in the statute and are presumed to be reasonable and in the best interests of the child. The factors for consideration are the age and needs of the child, the ability of the parents to contribute to the support of the child, any financial resources available for the support of the child, the amount of possession and access to the child, the net resources of the parent to pay support, including the earning potential of the parent to pay support if the actual income of that parent is significantly less than what that parent could earn if intentionally unemployed or underemployed, any child care expenses necessary for the employment of either parent, whether a parent has custody of another child and any child support expenses being paid or received for the care of another child, the amount of alimony being currently paid or received, provisions for health care, any educational or health care needs of the child, including college expenses, any benefits a parent receives from an employer, any debts or obligations of a parent, any wage or salary deduction of the parents, the cost of traveling to visit the child, any positive or negative cash flow from any assets, including a business or investments, any provisions for health care or insurance, any special or extraordinary educational, health care, or other expenses of the parents or the child, whether either parent has a car or housing furnished by an employer or other person or business, and any other relevant factor. Additionally, the court may order health insurance coverage for the child. Further, the court may order income withholding to secure child support payments. Texas is a community property state. The spouse's separate property consists of any property owned prior to the marriage, any property acquired during the marriage by gift or inheritance, and any recovery for personal injuries which occurred during the marriage will be retained by the spouse who owns it. The community property, consisting of any other property acquired during the marriage, is divided equally unless the court finds that unjust. In addition, the court may divide property acquired while residing outside of Texas, which would have been community property if it had been acquired while residing in the state. The only factor considered in the statute is a due regard for the rights of each party and any children. Any property possessed by during the marriage is presumed to be community property, unless shown that the property is separate property. A court can determine the rights of the spouses in any pension plan, retirement plan, or insurance policy. The court may award alimony only if the spouse from whom maintenance is requested has been convicted of family violence within 2 years before the suit for dissolution, or the duration of the marriage was 10 years or longer, and the spouse seeking maintenance lacks sufficient property to provide for his or her reasonable minimum needs, is unable to support himself or herself through employment because of an incapacitating physical or mental disability, is the custodian of a child who requires substantial care and supervision because of a physical or mental disability, which makes it necessary that the spouse not be employed outside the home, or clearly lacks earning ability in the labor market adequate to provide for the spouse's minimum reasonable needs. If the court determines that a spouse is eligible, the following factors are then considered in the award: the financial resources of the spouse seeking maintenance, including both separate and community property and liabilities, the spouse's ability to meet his or her needs independently, the education and employment skills of the spouses, the time necessary for the supported spouse to acquire sufficient training or education to enable him or her to find employment, the availability and feasibility of that training, the duration of the marriage, the age, employment history, earning ability, and physical and emotional condition of the spouse seeking maintenance, the ability of the supporting spouse to meet their own needs and make any child support payments, excessive or abnormal expenditures, concealment or destruction of any property by either spouse, the comparative financial resources of the spouses, including medical, retirement, insurance, or other benefits, and any separate property, the contribution of one spouse to the education, training, or increased earning power of the other spouse, the contribution of either spouse as homemaker, any marital misconduct of the spouse seeking maintenance, the efforts of the spouse seeking maintenance to seek employment counseling, and any property brought to the marriage. The monthly maintenance can be no more than whichever is lower, $2,500 or 20% of the paying spouse's monthly gross income. Texas official policy is to promote amicable and non-judicial settlements regarding children and families. Upon written agreement of the spouses or the court's own decision, the court may order mediation. The mediated settlement of the case is binding if it is signed by the spouses, any attorneys of the spouses, and provides that the agreement is not subject to revocation. Upon request, the court can order both spouses to consult a marriage counselor. If the counselor's report shows a reasonable expectation of reconciliation, the court can order further counseling for up to 60 additional days. With every divorce filing, the clerk is required to inform the person filing of the availability of marital counseling services. In addition, if there is a history of conflict and difficulties in access to any children, the court may order either parent to counseling. Visit us today at www.mydivorcepapers.com and click on Texas at the bottom of the page. Let mydivorcepapers.com help you file for divorce today.